deferred probation. Is that correct? And then in cause number 1828753, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation October 29th of 2018 for aggravated robbery, a first-degree felony. Again, that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count one in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
No, ma'am.
Not true.
Not true.
Count two in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true?
True.
True or not true?
True.
Count three in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
Not true.
Okay. Count four in each case alleges that you are behind in your court-assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those two are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations, and anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, you can go back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases that are relatively high. I believe they're.
Do you want to file a motion for some, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance if I've already had a hearing.
When the reset is, can we get a speedy reset? Your Honor, or how long?
You're going to get the same reset on a motion that we get so that everybody can get prepared and so that that updated report can get taken care of.
I'll be out to see you.
Good morning, sir. Are you David Wayne James?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Mr. James, in cause number 250522, you're charged with the third-degree felony offense of collision involving serious bodily injury from February 16th of 2025. And how do you plead to that charge?
I plead no contest.
You either did it or you didn't do it.
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Right.
All right. Then I'm going. I have here on the computer in that case some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, that's right.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Right, yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. And that, is that your understanding of your agreement?
Yes.
Okay.
The other case is, if you can't read my writing, it's extended probation and safety relapse.
Okay.
You can read.
I guess the length of time in the probation is something that, obviously, the length of time on your probation, because it's even written on here, on this one, I can give you any amount of time in probation, so I don't have to follow that 5-year. If I give you the probation and sentence you to probation, the 10-year term in prison, probate it for any number of years, you understand that you'll be waiving your right to appeal.
Right.
So the thing is, until I see an updated pre-sentence report and really see what's been going on, just on the face of this, it makes me have a little bit of pause because you're already on a felony probation and there's a new felony offense, And so I'm not sure that the length of time of only 5 years is something that I'm willing to go along with, but I'll take a look at it when we come back for sentencing. Do you understand?
Yes.
Your Honor, I've explained that to him, and I've explained to him that some courts don't even consider that. They automatically do it 10, but if you do everything you're supposed to do, the judge can always let you off probation early.
Correct. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number one in that case?
No objection.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Your Honor.
All right, sir, in 250522, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case so that the probation department can do a pre-sentence report, give me an update, obviously, on the probation case, as well as more information on this offense, and then we'll come back later for sentencing. Now, in cause number 1523545, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2017 for the offense of burglary of a habitation, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, February 3rd of 2025 in Jefferson County, Texas. And is that true or not true?
It's true.
Count 2 alleges that you committed the offense of possession of drug paraphernalia on February 3rd of 2025. And is that true or not true?
It's true.
Count 3 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically by associating with past associates who are actively using illegal substances. Is that true or not true?
It's true.
Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample January 27th of 2025 that tested positive for methamphetamine. Is that true or not true? Count 6 alleges that you failed. Nope, we're going to keep going. I want to know all of this if I'm going to consider leaving them on probation. Thank you, though. Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample on February 3rd of 2025 that tested positive for alcohol. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of February 3rd, 2025 in the amount of $1,689. Is that true or not true?
That's true.
Count 8 alleges that that doesn't really give me.
Yeah.
All right, I'm going to skip 8. Count 9 alleges that you failed to report to the probation department as directed on February 7th of 2025, and is that true or not true?
It's true.
Count 10 alleges that you were at a location other than your residence at approximately 11:51 p.m. February 16th of 2025. Is that true or not true?
That's true.
Count 11 alleges that you failed to submit to the alcohol or drug screening as directed February 11th, February 14th, and February 19th of 2025. Is that true or not true?
That's true.
Count 12 alleges that you committed that new offense of collision involving serious bodily injury February 16th of 2025. And is that true or not true?
That's true.
Did you enter your pleas of true to all of the counts except, let's see, 8, which is the one that I left out, freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Yes.
I have here on the computer some documents that have your signature on them in this case as well. Again, did you go over these with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
You understand if I follow the agreement that you've made with the district attorney that you would be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement in this case would be for me to continue your probation, extend it for 2 years, and order you to the Safe B Relapse Program. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your pleas of true to counts 1 through 12 minus 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case, again, to get an updated report about this case as well as a report about the other case, and we'll come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you.
Yes, sir. And Mr. Sanchez is currently on probation for the offense of driving while intoxicated, third or more. A motion to revoke was filed with the allegation that there was a new offense of driving while intoxicated from April 15th of this year in Wharton. Is that Wharton County or, anyway, it's in Texas. And then also that on April 15th, 2025, he was driving a vehicle that was not equipped with an ignition interlock device, and that he failed to abstain from the use of alcohol. Mr. Franklin has filed a motion asking that I set a bond. There's currently not a bond on the motion to revoke probation. Do you intend to call your client as a witness or no? Or,
Only if necessary, Your Honor.
go ahead and I'm trying to find, give me just a second. I'm looking for the old PSI.
I have my copy if you need it, Your Honor.
This one may be old enough where it didn't get,
It may be so old, but back then they probably weren't.
It was 2019.
okay. All right, you can go ahead, Mr.
Your Honor, we
Franklin.
have not been provided with a copy of the old PSI. That was not produced to us. So that was one of the issues I think that needs addressing. We also supplied
Mr. Nichols,
right up, I'm sorry.
go ahead.
We supplied, we filed with our motion about a dozen letters in support.
And I have received those and take judicial notice of the court's file that includes those as well. Thank you.
Thank you, Your Honor. In assessing whether Mr. Sanchez is a flight risk, I think the support from his community, from his family, helped provide evidence that he's not a flight risk. So the court should then turn to the prong of whether, of what threat he may pose to himself or others. In this case, the underlying offense was 2019. The motion was filed based on a violation, true, but there were not other violations as far as not reporting or failing other tests up until now. So that's been effectively 6 years that he's been compliant. We'd also like for the court to take note that the other offenses that are mentioned go back as far as 1992 to 1995, 2001, et cetera. In other words, it has been, in some instances, decades since those offenses occurred. And although we're not downplaying the severity of what Mr. Sanchez is currently charged with, we do think the court should take into account, as regards the threat to himself or others, the fact that the other causes are, in some instances, over 30 years old.
What's the status of that case in Wharton? Does anybody know?
Your Honor, it is my understanding, and I don't represent him on that case, but my understanding is that it is pending because this one fell first in the queue, so he was sent there first.
Okay. So they're going to wait for us to see what I do, I
That
guess.
is my understanding, Your Honor, but again, I don't represent him on that, but that's what I could glean. I spoke to a lawyer that he conferred with there, but he did not end up hiring that lawyer, so he couldn't speak,
Okay. All right, Mr. Nichols, what's the state's position with regard to a bond?
Judge, my main concern is him driving a vehicle that doesn't have an interlock. So we have no idea how much driving he's done. It sounds like the only reason we found out about this violation is that he got caught. I doubt that this is a one-time event of driving his wife's vehicle without an interlock. And so to protect the community, I'd ask that if the court does set a bond, that it be high enough to protect the community from his repeated driving while intoxicated.
Your Honor, may I respond?
Sure.
First, speculation as regards any other instances is probably not admissible. But secondly, there are measures that the court can take in assigning bond conditions to monitor Mr. Sanchez in such a way that he...
But he had probation conditions that were meant to monitor him.
Your Honor, as regards whether he's drinking, for example, there are scram devices and other devices that constantly test for alcohol in the system. The scram device, for example, tests every half hour.
Yeah, so here's where I am on this. Mr. Sanchez had at least, this is his fourth conviction that we know of for a DUI. I know there were some other arrests that we didn't have the disposition. Looks like, at least according to some of the information I've received, that there's been 7 or 8 arrests. This was a cap.
Including those as well, Your Honor.
Okay, that's overruled. They think with regard to setting bond under 17.15, I'm able to take into consideration everything that is at my disposal. And in fact, I'm required to take into account everything that is at my disposal with regard to prior offenses, with the most recent bail reform, as well as the ones from a couple years ago. So I guess my worry isn't necessarily the reporting or him fleeing. My concern is for the safety of the community. And this was a cap of 8 years when I gave him this probation, probably against the argument of counsel from the state, and gave him this opportunity. He's on probation, commits another. We're lucky we're not here for an intox assault or even worse. I am going to deny the motion for a bond at this time. If there is any likelihood at all that I would leave Mr. Sanchez on probation, it would absolutely be with some type of treatment. And so I'm not going to allow him to get out and even with the scram or anything else and put the community in danger. All right. We'll get it set for an announcement within about 30 days or so, and then we'll see where we get on the case.
Thank you, Judge.
Thank you, sir. You can go back with the bailiff. Good morning, ma'am. Are you Ebony Broussard?
Yes, ma'am.
And Ms. Broussard is on probation in cause numbers 19-32518, 19-32806, and 21-36615 for the offenses of escape while arrested, assault on a peace officer, and possession of a controlled substance. There's been motion to revoke filed in all 3 of those cases. And Mr. Nix, what is the announcement?
Your Honor, I've spoken with the state. I think we have something in the works. I think we'd both like a 2-week reset. And I think in 2 weeks, some offers that we made to the state to try to resolve these issues will be made whole at that time. And I think this will be worked out at the 2-week reset.
Any issue, Ms. Malfino?
Judge, I have spoken at length with Ms. Johnson, who has worked with this defendant for a long time now. Of course, respect her position ultimately in that she is the one who actually works with her. There are quite a bit of arrears due in this case. Ms. Broussard has been ordered previously to pay those with forms of income such as her tax return, et cetera. She has been defiant in doing that to the probation department. Mr. Nix indicates that she, via her family while she remains in custody, is able to do that in the next 2 weeks, and I'd like to reconvene at that time and maybe see where we are. Our position in the alternative will probably be ISF cognitive. In fact, if she does not get that paid, we may just go ahead and proceed with the motion. We'll be ready to do it on that day.
Okay, sounds good. Thank you for being here, Ms. Johnson. We'll reset the case for 2 weeks.
Thank you, Judge.
Thank you.